When you've been charged with for example, a crime of violence, it could be an assault, it could be an aggravated assault or an elevated aggravated assault. And these are just some examples of crimes of violence. One of the common questions is, but I was defending myself. Why am I being charged with a crime? Aren't I entitled to self-defense? And the answer is maybe. I'm going to give you an example. It's a classic law school example. I'm going to fight you, and I'm getting the better of you in a fist fight. But it's just a fist fight. You pull out a gun and shoot me. Were you entitled to defend yourself with your fists? Yes. Were you entitled to use the amount of force necessary to defend yourself and stop this assault? Yes. Was the gun too far? The answer is maybe. Maybe not. It depends on the circumstances of this fight. How badly were you being beaten? How fearful were you that this person was going to take your life? What were the objective facts? What would a reasonable person in your position do? Should the police have been called? Where was the location of the fight? Did it occur in your house? There's a lot of analysis that needs to go into whether or not you're going to be able to raise a self-defense argument. Generally, if you show up to a fight with a gun and pull the gun out during what's just going to be a regular fisticuffs melee, there's a good chance you're not entitled to that as self-defense. It's going to be some really interesting factual circumstances that would be necessary to support it. But self-defense is a legitimate defense, and I have employed that at trials successfully. You might be able to as well. One of the questions people will generally ask is, how am I supposed to fight this? I mean, isn't this just, they're just saying I did this. I mean, how am I supposed to prove I'm innocent? Well, it's not about proving your innocence. First of all, you have to remember you are presumed to be innocent. That's a constitutional protection. And we challenge the prosecution's evidence. How do we challenge that? We challenge it if we're at trial through the crucible of cross-examination. That's how you challenge evidence. That's how you begin to bring doubt as to the strength or merit of the state's case, by brick breaking down their witness, breaking down their legal theory to show support for your defense theory, because it's really a competition of ideas in the courtroom. Evidence is important. Some evidence may be difficult to get past. Other evidence can be explained away, and it just depends. But to challenge the prosecution's evidence requires skill in the courtroom, skill in advocacy. And if you're in trial, you need to have an attorney, a trial attorney, who knows how to conduct a proper trial and knows how to raise reasonable doubt with the jury through skillful cross-examination of the state's witnesses. Occasionally, people will ask me about an alibi. How could I have possibly committed that crime when I was in South Carolina? It's a good question. You couldn't have. And if you have an alibi showing that you were in a different place, you have a limited time to raise that alibi as an affirmative defense. But in this scenario, if you are charged with robbing a liquor store, for example, armed robbery, and the defense is you have an alibi at the time and on the date of the alleged offense, we can show you were in South Carolina visiting your grandmother at the nursing home. That is an airtight defense. I would imagine under this very simplistic scenario with these simple facts that this case would go away if it even made it to indictment. And it's a good reason why you would want to get us involved in the first place. If you're charged with that crime that you didn't commit and your case hasn't been indicted by a grand jury yet, it's a felony, it's got to go through the grand jury process, and we can show affirmatively proof that you have an alibi, we can present that to the prosecutor and perhaps avoid the case going to the grand jury for indictment, and that would be the end. So an alibi can be a very powerful defense, but it's up to us to prove it. Oftentimes, the only chance they may have for defense is if there was a search conducted. It was not lawful. It wasn't supported by probable cause. There may not have been affirmative permission given. Perhaps there's a faulty warrant. That's pretty rare. But you do have to look, as the defense attorney, at constitutional challenges to the evidence. You cannot just assume all the evidence was gathered lawfully. And that requires investigation on our end and may require challenging the lawfulness of that search in court through a motion to suppress evidence. So if evidence, say, oftentimes what we're talking about in my line of work, what I see is we're either talking about drugs or we're talking about a computer search for child pornography. Under those two cases, you do have to look at the lawfulness of the search, whether it was supported by a search warrant or not. Was there permission or not? And then you raise that issue and you litigate it, which means the state has to put on witnesses to support the proposition that it was lawfully conducted. We get to cross-examine those witnesses, and we may need to put you or other people on as part of our witnesses for the defense, and then the judge will make the determination of whether or not that evidence comes in. In the case of a drug case, if the drugs don't come in, they have no case. That's basically the end of it. So many times people are arrested for drug trafficking. They've got you on drug trafficking. It's whether or not they can prove it without the drugs, if those can be suppressed due to an illegal search and seizure. So those are issues that we always need to look at. I'm Attorney William Bly of the Maine Criminal Defense Group. If you've been charged with a crime and you've got questions about what are some common defense strategies and you're ready to get someone like us involved and you've got those questions, give us a call. The team at the Maine Criminal Defense Group is ready when you are.